Good morning. It's the 13th of March 2024. I'm Dr. Siram, and I'd like to address the issue of amendments to the Medical Board Act, which are being supported by the Council at present, which facilitate the Council's CME-Based DE-Registration of Medical Practitioners in the absence of an operationalized CME framework. So I'd like to read a statement on this, and I hope that the medical fraternity is paying very close attention, because these clauses are being they are included in the amendments to the Act, and they're being forwarded to Parliament on our behalf by the Council as we speak. This statement is entitled Continuous Medical Education Policy Recommendations for Consideration. It is agreed that continuous medical education, or continuous professional development, which is a term that has been adopted by the Council, plays an integral role in advancing the quality of care provided by physicians across all spheres of practice. Doctors should be incentivized and supported in accessing high-quality CMEs, which include interactive teaching and hands-on skill sharing by local and international experts. In the short term, adoption of a local CME framework, which enables CME provision and access, will encourage voluntary participation by physicians while a local culture of CME is being established. And this should occur over a period of a few years. The Medical Board comprises a spectrum of practitioners with differential access to formal training activities which count as CME. Doctors in tertiary centers and those enrolled in postgraduate programs routinely engage in activities which may be registered as CMEs. And in fact, in the last Special General Meeting, arguments for exemption from CME were already voiced by many of the practitioners. However, specialists and generalists in private practice and primary care have greater challenges in accessing and or affording CMEs. And I'd like to emphasize affording, because there are many physicians who are unemployed, registered members of the board who are unemployed or who are underemployed. Thus, the CME mandate inherent in the Draft Act 2024 may disproportionately affect this cohort of physicians, causing frustration and in some cases punitive deregistration of doctors who depend on practice for their livelihoods. Regardless of CME participation or submission at this time, no suitably qualified member of the board in good financial standing, with no convictions or professional disciplinary action before him or her, should be denied renewal of their licensure to practice. No suitably qualified member of the board in good financial standing and with no convictions or professional disciplinary action before him or her should be denied renewal of their licensure to practice. Medical practitioners who have committed years of service and study should not be threatened with suspension or erasure unless they are legally proven to be negligent or unsafe in practice. And this is what stands right now in the Medical Board Act. Yes? Right. In regards to having a positive and constructive conversation, here are some proposed components of a CME framework to consider. As CME certification and registration of CME points have not been rationalized locally, the board should consider, that is the board which is you and I, should consider setting up a CME regulatory framework to establish CMEs in Trinidad and Tobago. Components of this CME framework may include: 1. A listing of the CME categories, example pediatric surgery, family medicine, alternative and complementary medicine, psychiatry, pharmacology, nutrition, gastroenterology, cardiology, obstetrics and gynecology, public health, and of course bioethics. CMEs pertinent to a variety of practices, example general practice or primary care, public health, right, as well as the specialty practices, but in particular general practice and public health, should be made available to ensure that practitioners develop holistically and are able to provide effective, safe care, and to refer in a relevant and timely manner. Yes. 2. Criterion for registration of CME events should be established. Examples, lectures, workshops, and procedures. Assignment of CME points to these activities should be rational and consistent across the board. CME point allotments should be comparable to CMEs abroad. Yeah. We should establish a register of CME providers with clear professional and experiential criterion for registration of these providers. 4. We should establish an accessible online platform for the submission of CME activities and the collation of points, CME points. 5. Yes, an explicit policy for the conversion and accounting of CME points awarded in other jurisdictions or medical services away, right? And or through other accredited institutions. So there should be a policy for conversion accounting of CME points that are awarded in other jurisdictions. Yeah. 6. There should be a policy or there should be incentives for professional societies to conduct workshops and courses. And 7. We should consider a CME remuneration scheme for physicians who participate in such events, and particularly for many physicians who have difficulty in finding jobs at this moment. Yeah, and many new physicians are encountering that problem. Then they are unemployed or underemployed. In the absence of this operationalized CME framework, it is unreasonable and onerous to enact legislation which punitively deregisters physicians who fail to access or to provide evidence of CME participation. Yeah? Because there are many physicians who are actively studying and working all of the time. However, it is unreasonable to register such physicians who maintain a high standard of care and quality of care because of their continuous study. But the council deems them unworthy because they are unable to provide evidence of their continuous education. The CME framework then, so we need some time to set up this process and these procedures and to establish this culture. The CME framework should be presented to the board. So this framework, and we should discuss it as a board, and should be presented to the board for input and review. We need to work out the finer details, whilst the IT elements of the program are brought on stream. Once this framework has been operationalized, legislative amendments can then be revisited in the future, so we are premature, right? So I hope that the medical fraternity is paying close attention, and this is a matter that has to be dealt with expeditiously, and it is all of the clauses are not contained with regards to CME mandates or CME-based deregistration. They are not contained in the regulations that we voted against in the last special general meeting, but rather those clauses are housed in the Act, which is still being supported and forwarded to the Parliament. Okay, thank you very much, and we can stay tuned for further discussions on this matter. Thank you for your attention.